Yes, Mr. Barker.
Thank you, my lord. So we have decided to ask for permission to raise the jurisdiction issue. This is on the basis that.
Sorry, you'll have to start again.
Yes, my lord.
You raise your voice.
We would like to raise the jurisdiction issue.
That is, I mean, they're all jurisdiction issues in one sense. But
The-
you mean the issue about the failure to use Rule 11?
Yes, my lord. It's always difficult to judge these things when one comes into a case. One goes by what is stated in one's opponent's skeleton argument, and it looks like the case is developing in a direction that we had not anticipated. And in light of that, there is another reason as well, which is that the Rule 11 issue raises an interesting point, which the Court of Appeal has not previously had occasion to decide, and it is whether a defendant can refrain from filing an acknowledgement of service and challenging jurisdiction through Rule 11, and then challenge jurisdiction in a different context. So I was going to raise that within the costs appeal,
Yes.
of course, but
Well, I think there's an argument formally that it belongs as a further argument in the main appeal. Having said that, it's been developed in the context of the costs appeal. It's a self-contained argument, and I think, subject to anything Ms. Evans may say, it's probably better for her, or for Mr. Roberts, if it turns out to be him, to deal with it at that stage.
So can I just be clear? You're taking this point across the board.
yes, my lord.
So this is a complete answer to the case,
Yes, my lord, I would suggest so.
taken in your speaking note, which I saw yesterday, and your authorities, which I saw this morning.
And your skeleton argument, which is effectively simply a recasting of your speaking note.
Yes, my lord.
Sorry, we have two documents. We have a speaking note and something called
It's just been renamed.
I thought that
Mr.
was so,
Roberts-
because
Mr.
of
Roberts'
this,
suggestion.
I'm glad it's been renamed. It's what it really is. Okay, well,
May I propose, my lord? I'm sorry to interrupt.
yes.
That this argument be addressed after the arguments on the costs appeal. That would give my learned friend more time to consider it.
Well, if she or he want more time, I don't really mind when it's dealt with. I think the only point was that although in a perfect world, in a logical world, it'd be dealt with as part of the appeal because it's relevant to the appeal. I don't think that's sensible when everyone needs a bit of time to think about it. Whether let's just be clear what you're proposing. You're proposing to go first on it because you're taking the point.
Yes, my lord.
And you want to do it separately from your point about the correct approach to costs in this situation. It really doesn't matter, does it, Mr. Bott? I mean, you'll just make all your submissions in your cross appeal, no?
Yes, I anticipate so largely, but there might be differences in the costs appeal. The argument is slightly different.
It's completely different, but isn't it?
I'm sorry, the Rule 11 argument
Oh, I
is
see.
slightly different in the costs appeal
I see what you
from
mean.
its application to the main appeal. There are some nuances, and I would
Yeah,
propose.
you may be right.
I
You
would
may be
propose to
right.
deal with those.
Well, look, I'm not even again, subject to any views Ms. Evans, Mr. Roberts may have. I think I don't mind which order you develop them. I don't want to inhibit you if you think it's better to present it as a separate point after you've dealt with the other aspects of the cross point. That's fine by me. Us.
Yeah, and to hear it de bene esse.
Yes, well, that's really what I was. I was getting Ms. Evans to say that you've indicated that you may well have objections to the point being taken. But I think it will not be sensible to rule on those objections until we have understood what the point are and its ramifications. So when Mr. Bott does come to develop it, it will be all de bene esse, and you will be able to make any in principle objections to allow it to be taken after that, which frankly will be easier to make after that, I think.
Yes, that's fine by us. We will deal with it in the course of the costs appeal, but so that it encompasses what's been said today, if anything.
Yes. Very well.
Thank you.
Thank you.
Thank you.
Right, off you go. Well, you're not on that at the moment.
No, my lord.
Yeah.
So, my second argument is looking at things more broadly, and I propose to look at the case law and make some observations about Rule 6.34, and then my third argument will look at Rule 6.34 in more detail. So, I can make this fairly short because you've already been taken to a lot of it. But I did want to take you again to Shelftat. This is at tab 14 of the Authorities Bundle, page 326.
Thank you.
And this is the Court of Appeal's consideration of the Form N510 a couple of years ago. As you can see here, it appears that the Court of Appeal is endorsing the approach taken in Athena Capital. Namely that if you apply for permission under 6.34.2, then you need to apply for relief from sanctions. This is paragraph 24.
$34, did you say?
24, my lord.
Oh, 24, yes, I think you're on this point. Yes, thank you. Let's just have a look. Sorry, where does it say anything about relief from sanctions? Oh, sorry, I clearly haven't got over my lunch break. I was rereading 22. 24, yes, thank you. Now let me read that. Yes, I see. Yep, okay.
You have been taken to 22 already. I don't propose to repeat that. There is another decision that I do.
Both of these are under the heading Form N510.
Yes, my lord.
Because the issue in Chelfat was whether it needed to be in place when you issued the claim form. Nothing to do with service. Chelfat's to do with issuing it. The office had wrongly returned the claim form to Mrs. Chelfat, saying you haven't filled in N510.
Yes.
And the case was about whether the office was right to have done that, thereby preventing her from issuing her claim form in time. And the answer was no.
Yes, my lord. I'm not suggesting that this is binding. That this is the ratio of the case and that it's binding on this court.
No.
If that assists. Now, the other case is Rekarna Meets. This is tab 9, page 155. And paragraph 26, if I could invite the court to read that.
Sorry, which paragraph again?
26, my lord.
Thank you very much.
So this is the basis of your submission this morning, that the important thing is you put in an N510, not that it is right.
Yes, my lord.
Right?
So,
No court of appeal authority on that point. Is that right?
I beg your pardon?
No court of appeal authority on that point.
I'm afraid not.
Okay.
So, I don't propose to belabor this, my learned friend already has, but the purpose of the form N51, N510, if I may, is to firstly force the claimant to consider whether a service can be effected without permission. That's been done in this case. It was considered. The second point is to ensure that there are no equivalent proceedings on foot in different jurisdictions. That doesn't arise here. And the third reason is to give the other side, to give the defendant an indication as to the jurisdictional basis in terms of territorial jurisdiction that the claim is brought under without permission. And all of these three purposes have been fulfilled here because the defendant was given an explanation of that
What you mean in
the letter
in the
before
letter,
action.
yeah.
Yes. I would suggest that in terms of the coroner Mead's decision, even though, I mean, in my submission it was correctly decided that you don't need to tick the right box. I would suggest that the court should find that one should have a reasonable belief in the box that one ticks. I don't believe there is any.
But it's a non-issue in this case.
In this case,
A, because you didn't tick the form at the relevant time, but when you did, you ticked the right box.
yes, my lord.
Yeah. So I doubt if you'll be persuading us to write an essay on coroner Mead's.
Well, in case the court felt the need to clarify this.
No, I wasn't joking at you, but I think it's plenty to decide without going into every detail.
Now, but in any event, the point I'm making is that if Google win, then it is, in the words of Patiala or Patalia, it is a triumphant form of a substance, because everything that form N510 was meant to do has been achieved in the present case. And it would be a very surprising result if a form that does not matter at all was held to render a service ineffective. And in my submission, it would be more proportionate for the court to interpret Rule 6.34 in a way that gives the court some leeway as to how to deal with the lack of filing and service of Form N510. So in other words, give it a broad interpretation.
But perhaps it fits into another bit of your argument, but what about the good law case where there was no substantial prejudice to the wrongly served defendant, but this court said, albeit only by a majority, that in the context of what are what is effectively an application to get round what would otherwise be a limitation difficulty, you take a very strict approach.
Yes. So my submission would be that this case should be distinguished from good law on the basis that what we're dealing with here is an extraneous formal requirement as opposed to an actual claim form. There is no doubt that but for the N510, the claim form, particulars of claim, etc., would have been served on time and within the requirements of the rules.
Well, there's an oddity in this case, isn't there, that the problem in good law was that it meant that if any reservice or relief from sanctions, but for the relief, the claim would have been counted to the time limits in the rules themselves, the substantive time limits. This is a slightly different time limit. This is a time limit for service of a writ, or showing my age again, of a claim form.
Yes.
Once issued. There would be no problem in principle about you issuing fresh proceedings and serving them, because there's no you're already out of time by reference to the Equality Act. But no doubt, if you get permission, you'll be relying on the discretionary extension powers. So it's not quite the same limitation point as in good law. As you can tell, I'm thinking aloud here.
Yes, my lord.
But that is a distinction. Whether it's a relevant distinction, we'll have to think about.
Yes, and I would suggest that if 6.34 is interpreted in the way that I propose, then those sorts of considerations can be weighed up by a court at first instance in relation to this formal requirement of including a form N510. On ideal shopping, again, I think I'm going to finish fairly quickly because I don't need to take you to it, I don't think. Perhaps just maybe to paragraphs 144 to 146, just to make sure I make the point clearly. It's page 283.
Yeah. What in particular are you taking us to?
So if you look at those paragraphs, you see that in 144 there is a reference to the documents being served not being claim forms.
Because they were unsealed.
Because they're unsealed. And so I say that even when you come to that bit of the decision, it's completely predictable that Rule 3.10 wouldn't apply. It's a very different situation from the present case, where the claim form was, for all intents and purposes, served.
Well,
But
that just goes back to the point that you've repeatedly made, that N510 doesn't matter and that everything was all right except for the N510. That's been obviated, so service on the 5th is allowed.
Yes. Well, very well. I will take my your lordship's cue and simply just get to the point and say that it is in ideal shopping, the specific provision, if one can use that term, with 615, 616, and 7.3. Sorry, 7.63. Whereas in the present case, I say that the specific provision, the provision that is meant to deal with precisely this situation, is 6.34(2)(b). That is the specific provision.
the issue before the judge, and I appreciate we seem to be moving a long way from the issue before the judge, but the issue before the judge was, what's the test? Here you've got 634.2b, which simply refers to permission.
Yes.
So what test does the judge apply when considering whether or not to give permission? And the rule doesn't say, so it's a question of whether it's your case, which is relief from sanctions, or Google's case, which is its 7.5, 7.6. Isn't that right? I mean, it's a specific provision, but it just simply says give permission with no further structure as to how that might be done.
Yes. So in my submission, the way that this was dealt with in Athena Capital is perfectly satisfactory. If you are applying to effectively remove a sanction, which is that the claim form is not permitted under this provision to be served, then the relief from sanctions test is the one that applies. There is no reference in 6.34 to Rule 7.3.
Neither is there a reference to Rule 3.9.
No, there is.
That doesn't help you either.
Of course, my lord. But the difference is that when looking at 6.34, it says that you may not serve the claim form unless you've filed and you also serve the N510. So that suggests that if you go ahead and do so anyway, then there is a sanction. And that then raises the question, well, what is that sanction? And the answer given in Athena Capital is that the sanction is that the claim form hasn't been properly or formally served, to use the words in that decision. Now that, I say, is a reasonable interpretation of that provision, whereas importing the test in 7.6 puts an enormous gloss on the provision that no one reading it would have predicted. Just a final point, and I appreciate that the wording of these rules is a bit different, but it is worth observing that if I can take you to 7.42. 4.42.
Is that in the bundle?
No, my lord, it's not. It's in the white.
Look at the white book itself. Okay.
7.4.
What page?
It is page 380.
380.
Yes.
Yeah, thank you. Got it.
So this is the provision that deals with service of the particulars of claim. And 7.42 states that the particulars of claim must be served no later than the expiry date, if I can use that term, of the claim form. Now, if you go to 768 of the commentary in the White Book.
768.
Yes, page 387, my lord.
Yeah.
So you will see here that the consequences of not serving the particulars of claim within the before the expiry date of the claim form are that you apply for relief from sanctions.
This is 7.6.8. So the bottom of 387. Yes. Thank you. I'm not saying that's wrong, but there's no authority for it. They go on to do the case of Stout, which I vaguely remember, but that was on a different point, wasn't it?
Yes, my lord. It could be wrong, but the present learning on the issue is that if you don't
I
serve,
shouldn't have said it may be wrong in the presence of the editor-in-chief, should I?
let me. Oh, I'm sorry, my lord. Let me rephrase. It is
No, it's
possible.
I'm the one who put my foot in it, not you.
Yes, my lord.
Yes. Okay. Sorry. I mean, you basically submit that the note at 7.6.8 is obviously right,
Yes.
and you say what's the substantive difference between a failure to serve particulars of claim within the time limit where the claim form has been served and a failure to serve notice in form N510 or a copy of form N510 where the claim form has been served. Is that the point?
Yes, my lord. And I would add, if I may, that clearly the particulars of claim are a far more important document than the N510. It would be a very surprising result if the N510 was so much more important in terms of service.
Well, you can argue that both ways. Although you keep on telling us how unimportant it is actually the basis of the jurisdiction of asserted for the service out of the jurisdiction, whereas the particulars of claim are only that. They're particulars of claim where there will already have been brief details of a claim in the claim form. And anyway, I see your point.
Thank you. I don't propose to take you through it, but the requirement concerning the response pack is at 7.8. It's not particularly important. So that's my second argument. I say that I think I've already made the point. I'm not going to belabor it again. I propose to continue to my third argument.
Yes, thank you. It's very helpful. So this is where you're going to help us on the actual mechanics of 6.4.3. Sorry, 6.34.2b. Yeah,
I will make my best attempt, my lord.
I'm sure you'll do better than we did first time around. Yeah. Yes.
I'm sorry, my lord. I've been reminded of the acknowledgement of service. If you don't provide that in time, that's also the relief from sanctions test. Just for completion of the previous argument.
Okay.
That's the acknowledgement of service in
By the
response to a validly served claim form. You don't have an obligation to serve an acknowledgement of provide an acknowledgement of service unless you've been validly served with the claim form.
Well, my lord, I am going to argue the opposite. I'm going to argue that you do have a duty to serve an acknowledgement of service, even if you dispute that that service has been correctly effected.
Yes.
Because otherwise, you
goes possibly to the heart of the point that you're not addressing yet.
possibly, my lord.
But anyway, that's just another, you're relying on that as another instance of the relief from sanctions approach being used in pretty well all circumstances. And you say, why should it be different for the error which occurred in this case?
Yes.
Yeah.
It's a flexible test that can deal with any concerns or prejudices that might arise. Now, Rule 6.34, the question I would pose is, 6.34(2)b. The question I would pose is, what is its practical significance, if not to address situations such as this one? Now, in my skeleton argument, which perhaps I could look up. So, the basis of my submission is that this rule is not required, really, unless the claim form has expired. Unless the claim form has expired. Because you can always, if the claim form hasn't expired, you can always simply file and serve form N510.
Well, we made that very point in good law, but it's a bit different, isn't it? Where we're dealing with service overseas, you say you can always, if there isn't a time problem, you can always simply issue a fresh, as you're saying, you'd issue a fresh claim and reserve.
No, I'm saying.
Sorry, I may have misunderstood what your point is.
I'm saying that if you have issued a claim form on the 1st of January, and then on the 2nd January you serve the claim form, but you forgot about the N510, then all you need to do is to file the N510 and serve it on the other side. Possibly, depending on one's interpretation of these rules, how strict wants to interpret them, with another claim form.
Well, you can't, because, well, right, surely the second point is essential. What if you have not filed and or served? We'll come back to that distinction in a minute. If you have not filed a claim, an N510, then your first service will have been invalid. So clearly, apart from para 2, you'd have to start again. You'd have to serve the claim form again, this time having filed the N510. So surely what para 2 is designed to do is to mitigate that.
Right.
Because you can't cure it simply by filing the N510 belatedly, because the absence of the failure to do so has invalidated the service as well. That's how one works. Are we on the same page?
Well, so it comes down to how strictly how literally you want to interpret the provision. But even if you interpret it like that, then the position is you've issued a claim on the 1st of January. You have 6 months to serve it. If you have forgotten about the N510, then you file the N510 and then serve either it or the claim again. Now, I say in my skeleton it's not necessary to serve the claim form again because you've already done that, but that nothing turns on that. But if what your lordship is saying is that that's what paragraph 2b is there for, then surely...
Well, it's what 2, I didn't say 2b is there for. It's what 2 is there for. Because 2 requires you to serve the claim form again, doesn't it? Or to, strictly speaking, to serve it for the first time, but to deliver it a second time. At the risk of being repetitious, but just to make quite sure that I'm understanding where you are, if 2 didn't exist, and you have failed, you've forgotten about N510, so you've neither filed it nor served a copy of it, then you simply haven't effected valid service, full stop. And all you could do would be to start again. And reserve the claim form you served first time round with the having filed the N510 and serving a copy of it.
Well, if that's the interpretation, then paragraph 2 adds nothing.
Yes, I suppose you're right.
Sorry, say that again.
Myself.
If his lordship's interpretation is correct, then paragraph 2 adds nothing.
But I think that might be because we're getting confused with the word serve.
I beg your pardon, my lord. I will be more precise.
2 is saying the claim form may only be served once you've done A or B. So service hasn't happened. Service is can only happen, as it says, if you have A or B. Surely that's what.
Yeah, in a way, it too is perhaps not mitigating one, but it's spelling out the consequences of one. It clearly, since it's something you must do, then the consequences of not doing it are that you haven't effected service. 2 then goes on to tell you what you've then got to do. You've got the claim form may only be served once, that is after you have filed the notice, or if the court gives permission. That's obviously what you're putting everything onto.
And that raises the question: permission to do what? And the issue that your lordships raised before lunch was, well, what if you're serving in a place where it's very difficult, for practical reasons, and you don't want to have to serve again?
Yes.
Well, then you're asking for permission. Well,
but you're
not.
Yes, to spell it out, you're asking for permission not to have to reserve or redeliver.
Right.
Yes.
But in that case, so what you're asking for is permission to dispense with the need for form N510, because otherwise you would have to serve that.
As I say, it's the confusion. There is only one valid service of any claim form. What if the court gives permission is as to the service of the claim form. The claim form may only be served ... if you leave out A, if the court gives permission. It is permission to serve the claim form.
It's as another way of just putting, my lord, is you're really saying the claim form may only be treated as having been served if the court gives permission. But that's not what it says. We can all agree it's not very well worded.
So if I understand my Lord Justice Coulson's reading of this correctly, it is that if you haven't filed the N510, then the claim form may only be served either if you file it, or if the court gives permission to serve it without first filing N510.
Well, there might be all sorts of circumstances in which the court might give permission. But there are 2 options. You either file the notice, and that's when the claim can then be served, or if the court gives permission.
Yes, but again, I don't mean
understand.
to be...
It's my fault, I'm sure. I just don't follow how that could be read in any other way.
Well,
the claim form may only be served A, once the claimant files the notice, or B, if the court gives permission.
In that reading of the rule, it would mean that the rule has almost no application, because why would you ever want permission to serve the claim form without first filing the N510? That doesn't make any practical sense in my submission. There is no need for
Having
permission.
dealt with lots of procedural disputes over the years, I mean, the matter comes before the courts in numerous different ways. I mean, it may be, for example, that a claimant hasn't realised that he hasn't filed the notice, but there isn't a time issue. The matter arises in court and the judge gives permission. You haven't filed it, don't worry, they know about it. There's no time issue, I'll give permission.
But that would be then, if I may use that word, retrospective permission.
Yeah, you may. Now I understand it.
So
You'd be saying that the service you have already effected is good service. Yeah.
Yes, and that's precisely what happened in this case, for good reason.
Well, that brings us back to the point, what is the test to be applied? Was the judge right to have regard to general relief from sanctions, or should he have looked at it on the basis that it was invalid service and so therefore he needed to extend time?
Well, if that is the question raised, one of extending time, then the problem that arises from that is, what is the date of service? Because if the claim form...
22nd of April 2022.
But that is not stated anywhere in the rules. It is not said anywhere that the date...
May only be served once the claimant files the notice. That's when the notice was filed.
Yes, but then the claim form was not served afterwards.
No.
But what, there is nothing... The words, unless the court gives permission, are wide enough to give the court a discretion to give permission as at an earlier stage.
That's the submission.
That is my submission.
That's the point.
And if you read this, the rule can be read...
Until Rule 11 hoved into view, I thought that was the point in this appeal.
I beg your pardon, my lord.
Until Rule 11 hoved into view, I thought that the point you've just articulated was the point in this appeal.
Yes.
Can I just ask you
I thought so too.
a point about the filing of the notice and whether that is really the date? Because it says A, once the claimant files a notice, 22nd of April, or B, if the court gives permission, which rather suggests that's not linked to the date that you filed the notice.
Yes, that is precisely my submission, that the court can give permission for a different date, and in this case the court has done so, with the date being the 5th of April. And indeed, I would submit, and I appreciate that my Lord Justice Underhill alluded to this again before lunch, but the second paragraph should be read to include also permission not to serve the...
Yes, I was going to ask about that.
Yes.
That's really got to be your submission. In this case, you had a double failure, though they're obviously very closely related. But in principle, they could happen separately. One, to file, let's just say, file with the court the notice, and two, to serve a copy of the notice.
Yes.
On a literal reading, which I'm afraid does have some attraction for me, but you can try and persuade me out of it. This situation is only concerned with failure to, this rule is only concerned with failure to file, not with failure to serve. Now, you may say, well, that's will be a very odd rule, but it's what it says.
Yes, my lord, it is what it says. My submission is that the construction of the rule should enable the court to deal with the mischief that arises, or that can arise. The mischief that can arise is that either before or after the expiry of the claim form, it transpires that the claimant has forgotten to either file or to serve the N510.
Yeah.
Now, I say that with filing, there is no issue at all. I don't propose actually to repeat what I've already said, but the point is simply that the rule should be interpreted broadly enough to deal with that situation. And that for the rule to have any real practical applicability, it needs to be interpreted fairly broadly.
Well,
I appreciate that there is a degree of mechanics
it'd
about
certainly be
service.
very. It would be much. It's not that it could never happen. I can imagine it quite easily happen, but it would still be rarer to have issued but then forgotten to serve a copy than to have not issued in the first place. If you're not issued in the first place, then you can't serve a copy because there isn't a serve a copy of. Yeah, I'm just trying to think out the practicality. The answer is either could happen. That's all we could sensibly say.
And I would submit it shouldn't be the case that in the case of an innocent oversight, you have a rule that cannot deal with that situation in a just and fair way in accordance with the overriding objective.
So how would you read? We're looking at 2, obviously. So how would you read it?
So I would read it to mean that where the claimant fails to file with the claim form a copy of the file with the claim form or serve a copy of the notice. The claim form, fail to file a copy with the claim form may only be served if the court gives permission to dispensing with the filing and or service of the notice. So if the court gives permission to dispense with the filing or service or both of the notice.
It's actually badly worded in another way, isn't it? Because 634(1)(a) talks about filing with the claim form a notice. That's the original. And then it uses the language of a copy of that notice when it comes to B. But the failure at the beginning of 2 is where the claimant fails to file with the claim form a copy of the notice. But it must mean, I mean, if it was being, it ought to say fails to file with the claim form a notice, not a copy of the notice.
Indeed, my lord.
Yeah.
Yes.
I'd suggest it is filing.
I'm not sure. I mean, it's.
So anyway, your helpful reading is in relation to B. If the court gives permission, and you say you would read to dispense with the filing or service of the notice.
Yes, or both.
Yeah.
Thereby treating as valid what would have been otherwise invalid service.
Yes, my lord. Yes, I feel like unless I can assist your lordships further, I have made my
You've been very
sentence.
helpful insofar as you haven't been able to advance a completely coherent analysis. I think that's because the wording doesn't permit of it. Well, there's got to be some give somewhere, and you say where it ought. You said what is the one that produces the most sensible result.
Yes, in light of the wider
Right.
circumstances.
Thank you very much. Yes.
My lords, excuse me, I only have one point in reply, subject to anything that you wish me to deal with. It's a factual point which came up at the beginning about the letter before action,
Yes.
which you were shown, which is in the supplemental bundle. And I only deal with it because I think my learned friend put some weight on it as a form of notice. The reality is that the only time, these are on my instructions as I've always understood it and confirmed again, the only time that Google solicitors have ever seen the letter before action is upon it being provided in the course of these proceedings by Mr. Bock. Now, that's not an accusation that he's not telling the truth at all. It's just that it's never found its way, if it was sent to Google and received.
But who was
through
it sent to? I'm afraid I didn't take in. Was it sent to Google or was it sent to Pinsent Mason?
No, Google,
Yeah.
because it's prior to, I suspect, the claimant knowing anything about any solicitors being instructed. Page 204. It's sent to Google LLC, Attention Legal Department at Mountain View.
Yes,
204 or 192? Or are they different?
Sorry, what was the other page?
192.
I think it's a duplicate.
Sorry, 192 was the letter before action. So isn't 204 the letter accompanying the
Oh, sorry, yes. I've got the wrong
Right,
reference.
no, that's fine.
No, you're right. Sorry, but it's the same address.
Yeah.
And it's the same point that what is described as the letter before action has not, for whatever reason, ever found its way through the large company which is Google.
we don't know. Mr. Bott does give evidence about the formalities of how it was sent. I forget whether he says whether it was sent recorded delivery or anything like that.
It was a process server.
No, the
letter itself.
the process server was for serving the process, but
Yeah,
the
yeah.
letter before action, was that all? How was that sent? What's the evidence about how that was sent?
Mr. Bott will have to assist with that.
It's page 202 of the supplementary bundle, my lord.
Page 202.
Of the supplementary bundle.
So it looks like it was posted and tracked. So some sort of registered post.
That's very helpful. So this is the letter before action. Is it?
Yes, my lord. 202 and 203.
I'm not saying this is wrong, but is that is this covered by witness evidence? You can't.
No, my
It's
lord.
exhibited to a letter or something. I mean, sorry, is this exhibited to your witness statement saying this is how we sent the letter before action?
No, my lord, but the issue of it not being delivered was only raised by Google at the time they were putting together a chronology.
Yes, I see. And at that point, you produced the. Well, there we are. We're not going to get to the bottom of this, I suspect.
No, so it's a point just about something which is in dispute, in
Right,
effect.
thank you.
My lord, I didn't propose to make any other points in reply, so I'll be repeating myself.
No,
unless there's
thank you. That's
anything-
always a good.
Could I just ask you one question then, with my lord's leave?
Of course.
Could you just deal with the very last point that Mr. Bosch made in relation to 634(2)(b), and he says there's no reason why you shouldn't read that as saying if the court gives permission to dispense with the filing or service of the notice.
Well, as you would expect, my first response to that is that it doesn't deal with the 7.63 problem, because as I spent some time explaining, the
Yes, but,
7.63 regime is
But what does it mean in its own terms?
To be honest, I don't think anybody knows what it means. I mean, that is my honest response to it. My reading of it is that the stress is on making effective the service of the
Stress is
proceeding,
on.
making effective the service of the claim form, because that's what the only reason for having to file this form at all, in terms of how it's put in 6.341, is that you're filing it so that you're putting in your statement of why you're using 613 and don't need permission. You're serving it, that's in B, because the defendant, as we've been through, needs to know why you're using that provision and whether there's a challenge open. But when you get to 2, the only concern is with the absence of filing. And the consequence of that seems to be simply that absent taking action in A or B of 2, as I think my lord said, there is no effective service if you haven't filed. So all that is clear about subparagraph 2 is that filing it in that situation seems to cure the problem, putting 7.63 to one side. And as to B, there's no test in it. So it's not clear whether that's intended to then allow you to effect service. But I can see that you would be able to effect service if you were filing the claim prior to the expiry of the
But
service
then,
period.
my lord, sorry to take over, my lord, but then the question is, suppose you're right, as it were, it's there to cure, it's there to render service effective. Effective as at what date? Assuming there's no out of time problem, you're well within the 6 months.
I mean, my interpretation of it is that the date would be the date that you then serve, having then remedied by filing. Or alternatively, if you haven't remedied by filing and you've made an application, and the example that my Lord Justice Coulson gave of a rather on the hoof situation in court perhaps is one, that date of that hearing with that order giving permission, it would tell you when you should serve, so serve within 7 days. So it's not as if there's no control over service so that you could never know what the date would be.
So, sorry, just to clarify, you contemplate 2 requiring another service? I mean, no retrospective.
An effective service, in the sense that it's predicated on there not having been an effective service because the form hadn't been filed. So even if you're physically, even if you physically sent a copy of the claim form, but without the form, that's not effective service. So once you file it, again, all within time, and you then send the form again, or even, I suppose, send a letter saying, I've now filed it, so please now treat the claim form that I sent to you last week as service. The service becomes effective once you've filed, and you can then say that the claim form's been served. In practice, you're likely to send it again, I would have thought.
Yeah. If you're in the 6 months, then anyone well advised is likely to send the whole thing again.
This is all assuming you're within time.
But assume that for whatever reason you are in the 6 months and you don't, and you say, by the way, the file we've now filed it. Are you saying it is from the date they receive the letter or the date that the ineffective delivery becomes service?
I would have thought that it can't be from the date of the ineffective service without the permission of the court, saying.
Can we perhaps take it in 2 bits? I mean,
that's the date.
The first thing to note is the actual operative provision of 2 is the claim form may only be served, not may only be treated as having been served, may only be served. And then in 2 circumstances, once the claimant files the notice. So on a literal reading, that means you file the notice and then you serve it again. That's literal, but a bit silly. I mean, you'd expect that to be the position anyway.
Yeah. But I think sorry.
But perhaps that is really only, as it were, prefatory to saying, well, if you do not do that, you've got to get permission. And then the question is, permission to do what? It must be not to have to reserve.
Resend, yes.
That's how I see it at the moment, but it's not made easy for us.
I mean,
sorry.
No, I'm just going to reiterate my agreement that drafting leaves a little to be desired.
To that point. Can I just ask you, and what do you say the answer to the point Mr. Bock makes, which is you said yes, but the test will incorporate 7.65, the rest of it. And he says, well, yes, but if you actually validate it back to this period, then you're not in 7.6 at all.
The response to that is that that appears to be classic bypassing of 7.63, because you're attempting to do what 7.63 is the power to do, which is to extend the time. And 7.63 in practice will do it by saying, okay, you served it late, but we'll say it was served then, 2 months late, but we'll say that was valid service. But the proposal here is that you don't have to do that. You just get the court under 634 to do it, but with no 7.63 discipline or test.
That actually comes down to a semantic point, doesn't it? Because the rules, certainly the rules in 7.5 and 7.6 envisage if you're late, you apply for an extension. If it would be slightly coach and horses territory if everybody got round 7.5, 7.6, whatever the circumstances, by saying, well, I'm not applying to extend, I'm applying to have it backdated.
I mean, it's precisely the point which I think was made in Ideal Shopping, quoting from the Vinos cases. So looking at, for example, 69, which quotes from Vinos, paragraph 20,
What page is that?
page 263 of the authorities.
Thank you.
The quote from Vinos, citing Lord Justice May, he says, what Mr. Vinos in substance needs is an extension of time. Calling it correcting an error does not change its substance.
Right, anything else?
No, my lord.
Very well.
Thank you.
So now we are moving to Mr. Bock's appeal,
Yes.
which will incorporate as a separate subset his new point.
Thank you, my lord.
Yeah.
So I propose to first relatively briefly deal with the inadequate reasons point. I think that will take maybe half an hour at most, perhaps less. And then afterwards discuss why the decision was, I'll use the term unprincipled cost decision, and that'll be by reference to the jurisdiction issues. The overarching point being that if jurisdiction ought to have been raised within the structure of Rule 11, then it is not fair. It is not it is not legally correct for Google to be awarded their costs on the jurisdiction issues in a relief from sanctions application. I am in your lordship's hands as to the detail to which to go into. Has the court had an opportunity to read Swivel and all this, or should I take?
Speaking of myself, without prejudice to anything I may say about their relevance when I read them, I haven't read the underlying authorities. I've simply read the skeletons. My lords may moan very inwardly and say they've read it all, and why should you have to go at my pace? But that is the fact.
I have read, and I am familiar with Swivel in any event.
Thank you, my lord. Well, perhaps I'll take you through it briefly when I come to it. Could I take your lordships to core bundle 7, tab 7, page 84, please? this is the this is the costs order, and I'm sorry, it's page 83 first. This is the costs order. This is the summary of the argument made, and you will see there that at paragraph 4, Judge Grout says, Mr. Bosch submits that, notwithstanding what appears to be the general rule, so this is the rule in Swivel, that the applicant in a relief from sanctions application pays the costs. So notwithstanding that, in relation to the costs occasioned by successful relief from sanctions applications, there are special reasons here to depart from such a rule. Most notably, Mr. Bosch says, the defendant took a point on jurisdiction which was dismissed, such that any costs occasioned with that should not fall to be borne by the claimant. Now that, I say, is not nowhere near a summary of the argument actually being made. The argument actually being made was that the jurisdiction issues fall properly outside of the relief from sanctions application. The jurisdiction issues should have been brought by the defendant in a separate application, notably under Rule 11, and therefore the general rule in Swivel shouldn't apply. And this, I say, of course, is supported by the reason for the rule in Swivel, the maxim, when the reason ceases, the law ceases. Sessione ratione legis, all this comes to mind. The rule in Swivel is predicated on the notion that one applies for relief from sanctions for a procedural mistake that one has made. However, the jurisdiction argument here, especially the argument on territorial jurisdiction, had nothing to do, I say, with the claimant's procedural mistakes.
And just for clarity, the jurisdiction argument was the point that said that the claims under the Equality Act were not within the court's jurisdiction.
Yes, so that was the dispute. There are two jurisdiction issues. Perhaps I can clarify that. The territorial jurisdiction issue is the one that your lordship just mentioned, and this is whether the Equality Act claims came within the contractual jurisdiction clause between the two parties.
Yeah.
The second jurisdiction issue goes to whether or not there was valid service.
Yeah, and so that point is obviously linked to the relief from sanctions.
It does have, yes, it is connected to the relief from sanctions issue.
Well, have I misunderstood? The point that you were saying had nothing to do with that was what I called myself probably inaccurate, the 633 point, that had nothing to do with the relief from sanctions. That's
Yes.
a point that would have had to be fought anyway,
Yes, my lord.
if assuming they took it. And it's a pure accident that it's been taken in the context of the relief from sanctions, and you won on it, and therefore you shouldn't have to pay all the costs. Is that the point?
Yes, my lord, and I would say it's not respectfully, it's not a pure accident. I objected to this from the very beginning, to bringing this point within the relief from sanctions application.
Yes.
Quite strenuously, actually, but so the point here is that paragraph 4, if I may continue.
Of course.
Yes, the paragraph 4 does not summarize the main argument being made, and then if you turn the page, you see at paragraph 7, it says, notwithstanding the court's broad discretion on the matter, I see no reason to depart from that general approach. So this is the approach in Swivel, the general rule that the claimant pays, the applicant pays the costs. As I have made clear in the judgment, this was not a case where the defendant had sought to be opportunistic in opposing the application. On the contrary, etc., etc. And then it says, I am satisfied, perfectly reasonable for the defendant to oppose the application. The fact that it raised a jurisdiction objection as part of its opposition was not an unreasonable course to take in the particular circumstances. So again, the decision of Judge Grout doesn't deal with the argument actually being advanced. Now, I would like to take you to the argument, if I may. Perhaps the easiest way to do this is so this is at page 49 of the supplementary bundle, tab 4. And you see there at paragraph 22, there is a summary of the arguments. There are 3 arguments being made. And the first argument is the jurisdiction issue was, for all intents and purposes, separate from the relief from sanctions application, etc.
These are the reasons why the general rule should be departed from,
Yes, my lord.
which is precisely how he summarised it in paragraph 4. Mr. Bosch submits that, there are special reasons here to depart from the general rule. And these are your reasons.
Well, he doesn't say that the special reason is that the jurisdiction, well, perhaps if I could invite your lordship to read paragraphs 23 to 27, you will see there how the argument was made.
Yeah.
So, just to reiterate the points, if I may, there's a point about causal connection between the procedural error and the matter being decided. There is a point about the purpose of the general rule being to quote-unquote punish or sanction the applicant, relief from sanctions application, and that reason cannot be applicable on a matter that's unrelated to the procedural mistake. There is a point being made here about a windfall for Google, because if they had brought this correctly under Rule 11, the costs would have followed the event. And there is a concern about the scope of this reasoning, because what is to stop a respondent, for example, from bringing a strikeout application within a relief from sanctions application and then getting the applicant to pay the costs? So that was the argument being made, and I say that argument was not dealt with by Judge Grout. Now, I propose to take you to some authorities on this.
Authorities on reasons.
Yes, my lord.
Right, well, we're pretty familiar with them, but there may be some key points you want to make.
Perhaps I will just take you to one very quickly. Flannery and Halifax, classic.
I think you've chosen the one which I think we
All right,
know.
understood.
Flannery is in the blood now.
Yes, my lord. Well, I will just summarize the points that I rely on in that case. The first point is that judicial decisions must explain to the losing party why it lost. And this means dealing with the main contentions that are being brought. So if I am losing, the court should explain why my arguments have not been accepted. Now, I understand and accept that the court will not deal with every argument with every contention and so forth, but the main argument should be dealt with, I suggest. The second point, which is obvious, of course, in Flannery and Halifax, is that the appeal court cannot infer the reasons. So in this case, this is something that my learned friend suggests that it can. In this case, you cannot infer from what Judge Grout wrote that he had actually read and understood the arguments being presented. And the third and final point is that it concentrates the mind. It's, of course, the well-known dictum. And in my submission, if Judge Grout had actually thought about the argument being put, he would have paused, because he would have struggled to explain why the claimant should pay the costs of Google's territorial jurisdiction challenge. And that, I say, is an error of law. Now that deals with the first ground, so to speak. The second issue is that regardless, the decision itself was unprincipled. And for this, I propose to take you to the case of Bolton, if I may.
Yes, to what, sorry?
The case of SCT.
Whereabouts in the authorities bundle?
This is at pad 19, my lord. Page beginning at 389.
Yeah.
I am somewhat in your lordship's hands here as to how much time to spend on this. I bring it up.
It's not a case I'm immediately familiar with. I dare say it may ring a bell when I read it.
Yes, my lord. The reason I bring this up is in response to Google's suggestion that a cost decision can only be overturned on appeal if it is perverse. And I say that's simply not the case. Whilst I accept that the threshold is high, where there is an error in the reasoning, a legal error in the reasoning of the lower court.
If you're there on reason, if you're there on reasons, we've got to retake the decision anyway.
Yes.
Send it back. So this only arises if you're not there on reasons. We think the judge's reasons are adequate, and then we have to decide whether they were wrong.
Yes.
You would no doubt say the only test, like everything else, is wrongness, not perversity.
Yes, my lord.
Okay, where's your key passage in this?
Well, there are a couple. So first of all, just from the head note, the facts. Perhaps I can summarize them. The facts are that in this case, there were several parties. The costs came to something like £50,000, but the circuit judge, somewhat arbitrarily, imposed a cap of £15,000 that could be claimed from the defendant. Now, the defendant was Mr. Bolton. He had refused to pay installments towards an outstanding car finance loan because the car wasn't working properly. Very run-of-the-mill case. But the circuit judge felt that the costs were disproportionate to the amount involved, and so imposed this cap. Now,
Where's the point of principle from our point of view?
yes, my lord. So it begins at paragraph 2, where Sir Nicholas Wilson says that generally costs appeals are overcast from start to finish by the heavy burden imposed on the appellant because it's contrary to the general policy of the court, and it's undesirable for additional costs to be incurred in fighting about costs. This is a paragraph on which my learned friend relies.
Yep.
But interestingly, in this case, in spite of that, the court did overturn the circuit judge's decision. Now, the main reasoning of Mr. Justice Wilson is at paragraph 30 to 36. Perhaps I could invite your lordships to read this.
Well, I mean, let's say we're not concerned with the detail of the reasoning because it's a very different situation, isn't it? Unless there's something, some analogy that I can't draw. It's simply that despite the high threshold, in this particular case, he found an issue of principle, an error of principle in the judge's approach, and overturned it.
Yes.
Do you get anything more out of that, out of this case, than that? Maybe
Well,
you do, but I can't at the moment see how it helps.
It perhaps shows the well, perhaps if I can take your lordships also to paragraph 47, 48 and 51. This is Lord Justice Ricks's reasoning. The reason perhaps I could preface this. What the court is looking at is the practical justice that the costs order achieved, or practical injustice in this case.
Yes.
And it is rectifying that practical injustice on appeal. That's the point that I'm getting at.
Yes.
Because they found expressly that the judge's decision below was unprincipled.
Yes, my lord. And so I say the judge's decision below is unprincipled.
Well, you have to in order to clear the high hurdle.
Yeah.
Yes, my lord.
Is that any more you need to get out of this?
No, my lord. I wanted to show how an example of that being applied
Yes.
by this court.
Mr. Bosch, I should tell you, I'm familiar with SCT only because it's about the only case in which I'm aware that this court did overturn a cost decision by a judge below. So it tends to get, in cost appeals, it tends to get more than its fair share of citation.
Thank you, my lord.
But as you say here it was unprincipled for the reasons set out in your skeleton.
Yes. So the summary of the argument I propose to make is as follows. I will come to more authorities on the jurisdiction issue, of course. So the first point is, would it assist the court to take you to swivel as well, to the relevant three paragraphs?
I've seen obviously what it says. I've seen the passage cited from the judgment of Miss Justice Martha Smith.
Yes, my lord.
If all it's saying is, other things being equal, if you've created a situation in which you need to have relief from sanctions, you should have to pay the costs, even though you have you've been successful in opposing the opposition, in overcoming the opposition. That's fine.
Yes.
You say that's not the point here. The point here is that an extraneous point was introduced, which had nothing to do with that issue.
Yes.
Namely the what I think of as the 633 point.
Yes.
That's really the point, isn't it?
Yes. Now, I say that in particular, it's not. So in response to that, perhaps I can take you to this. In response to that, my learned friend says, in her skeleton argument, is perhaps unhelpfully stuck in at the end. So, supplementary bundle. Tab 23, page 314.
314.
Yes, my lord.
Yeah.
So she says that Google had no choice but to raise the territorial jurisdiction issue at that point. Perhaps if I could invite your lordships to read paragraphs 27 and 28, please.
Okay. As he said.
So she says that jurisdiction is a matter that has to be raised at the first available opportunity. And that, of course, begs the question as to when and how jurisdiction should be raised. And the argument that I will make is that jurisdiction should have been raised under Rule 11. I will, of course, come to that in a moment, but it is not an issue that should be within a Rule 3.9 application, not least because a relief from sanctions application is not concerned with merit. It's not concerned with the underlying merit of the issue. And I appreciate I'm not talking just about the merit of the substantive claim, but it should also not be concerned with the merit of, for example, an unrelated contested procedural issue such as jurisdiction.
Is it right that you never have any regard to merits? I mean, is that not part of all the circumstances of the case?
Only in clear cases, my lord. So there is a very clear.
That's the problem, if I may say so respectfully, with Denton and White. That you end up, or can end up, on a huge trawl through points. And judges up and down the country have to listen to counsel banging on about all the circumstances, which very often does include the merits.
Yes, my lord. The case law, of course, there's no case law on this before the court, and I do not propose to bring it, but the case law certainly that I'm familiar with says that the court should only consider the merits of the case if it is a very, very clear case.
But every counsel says this is a very clear case where you should consider the merits. So the judges end up having to consider the merits.
Well, my lord, perhaps it is wrong, and perhaps they shouldn't have to consider the merit at
I
all.
understand that, but that's where we get. I'm afraid that's where we get to. That's one of the downsides from this side of the room. That's one of the downsides of Denton and White.
If you're truthful, the issue arose in other contexts long before Denton and White. In any kind of discretionary interlocutory decision, you are always being invited to look at the underlying merits. And it's quite a sour song sometimes, but the judges don't always resist, quite apart from counsel. But there you are. The fact is that in all the circumstances of this case, you can't rule out some consideration of the merits because they are potentially relevant, despite the self-denying ordinance that we won't have a mini trial. Anyway, there we are. You say this relief from sanctions application, going off into a quite separate point about whether there was jurisdiction under 633, was not appropriate.
Yes, my lord.
Or in any event, even if it was appropriate, it must be recognised for what it was, which was an adventitious opportunity to deal with a point that would have had to be dealt with on some other occasion anyway.
Yes, and crucially, where costs would have followed the event.
Quite.
Now, on the jurisdiction issue, because of course I say that is a general point, just like in a relief from sanctions application, you shouldn't be able to say, well, the court should not grant relief from sanctions because it's an unmeritorious case and it should be struck out anyway. In the same way, the respondent should not be able to say, well, there is no jurisdiction for the claim, or there is at least a dispute about jurisdiction that should be resolved within the application. But on the second issue, that is so much more the case because there are specific provisions for dealing with jurisdiction. And they are, of course, in the form of Rule 11. Now, in my speaking note / supplementary skeleton, I've quoted there. I haven't quoted Rule 11 itself, but I've quoted a bit from the White Book commentary.
So we just look at Rule 11.
Yes, no.
And which bit of your skeleton? Sorry,
This is the supplementary skeleton, paragraph 3. My lord.
paragraph
Paragraph 3, my lord.
2,
3.
3.
Yes.
Cost being apportioned.
No, of the speaking note, my lord.
Yes. Well, it's
Sorry.
also AKA supplementary skeleton.
Okay.
They are absolutely identical, aren't they?
Yes, my lord.
You just retitled it in order to get a point to acknowledge it was a supplementary skeleton.
Yes, my lord, at the invitation of our learned friend.
I know.
So this is responding to Google's new argument, which is what?
The argument set out at paragraphs.
Well, just summarise it for me.
The argument that Google had no choice but to object to to dispute the court's jurisdiction because you must
Otherwise,
do
they
so.
would have been found to have waived, or an issue estoppel, or I can't remember. There were various ways, but it's the passage you showed us in
Yes,
skeleton argument.
yes, my lord,
Yeah,
precisely.
Thank you.
And your short point is that they should, if they wanted to do that, do it under CPR Part 11.
Yes, my lord.
And I'm just looking, that's why I wanted to read the rule. The rule itself doesn't say it is mandatory, or does it, to apply under this rule. It simply says 11.1, a defendant who wishes to dispute the court's jurisdiction may apply to the court for an order declaring it has no such jurisdiction, so on. But the case law says what you have quoted from the White Book note. Is that right? The White Book note hasn't come out of nowhere. It's presumably based on authority.
Well, there is a bit of a difficulty there, my lord, because that's not exactly what the case law says.
Well, that's what I hope you're going to show us.
The case law says that if the defendant submits an acknowledgement of service, then Part 11 is obligatory. That's what was held in Hodinot.
Yes.
And that then begs the question, what is the position if the defendant simply refuses to submit the acknowledgement of service on the basis that it disputes jurisdiction? That is what has happened in this case. I can take your lordships through the correspondence if need be. It does shed some light on it, but it's not perhaps crucial for the...
Well,
for the legal court.
you'll take us to the cases, but simply on the face of that difference, isn't the answer that an acknowledgement of service is the first potential step in the proceedings? And so if as a defendant you don't then make a jurisdictional challenge, you're deemed to have accepted jurisdiction.
Yes, my lord.
Whereas if there isn't an acknowledgement of service, that deeming can't happen, or potentially can't happen.
Yes, my lord. That is the difficulty.
That would be my answer simply. But I am not familiar with these cases, so you're going to have to take us through them. But I just to make that point, that would seem to me to be a potentially logical difference.
But it is, I mean, just picking up that point, as Google had recognised, even if they didn't acknowledge the service but took part in the proceedings, they would then have to dispute jurisdiction. And I suspect it probably comes down to whether we're in, as was submitted this morning, a special procedural code for extending service, as we might be for disputing jurisdiction.
That is the argument that I propose to make, my lord.
But just to help me on this, it's a long time since I've done lots of these, but what the rules provide for is surely that you do acknowledge service, but at the same time make an application under Order 11 to preserve your position. I forget whether it's a single piece of paper, which is both an acknowledgement of service and, or whether you just do them contemporaneously. But that's how you're supposed to do it, isn't it?
You tick the box on the
Yes.
acknowledgements saying dispute jurisdiction.
That's right. That's what so.
If it assists your lordships, I can take you to the acknowledgement of service. It's in the main bundle at page 102. Tab 9, page 102.
Thank you.
Page 100.
Yeah,
two,
okay,
my lord.
that reminds me. Yes,
102.
now I've seen it. Of course, I've seen it on slides before. So,
Wait a minute. Mr. Bosch is very kindly giving me the page number. And I can't hear him because you,
keep up.
I'm sorry, I'm not as quick as my daughters, you probably realised. Page
102, my lord.
102, thank you very much.
Paragraph 3.
Yes, my lord.
And the rubric against it. Yes, I see. So you, in a sense, we're both right. You tick that to preserve your position, but you do nevertheless have to make a separate application under Order 11 within 14 days. That's what the rubric says.
Yes.
You don't file an application dispute. Is that right?
Yes, my lord.
So even if you ticked that box at 3, but you don't follow it up within 14 days, it doesn't help you. Is that right?
Yes, then you're deemed to have accepted
well,
jurisdiction.
thank you. Now more or less there.
So yeah, so that I say is the normal course. That's the normal procedure that ought to be followed, and the arguments I intend to make include. I'll come back to this. That well, a would-be defendant shouldn't be rewarded, certainly not with costs, for not following that procedure. And of course, it has implications for the main appeal also. Perhaps if I could begin by taking your lordships to the case of Hoddinott against Persimmon Homes. So this is in the, forgive me, in this supplementary appeals bundle.
The supplementary authorities bundle.
Yes, yes, my lord.
assume that the conclusion in this case leads to the note that we've just seen on the acknowledgement of service.
It's
I mean, this authority in 2008, I'm sure then reflects, it reflects almost precisely the acknowledgement of service form reflects precisely the head note in this case.
that is quite possible.
Right. This was a case where they didn't even tick the box.
True.
Isn't that right?
Yeah. Not indicating an intention to contest jurisdiction.
Yeah. So where do you want us to go with this?
So, firstly, paragraph 22, please. In fact,
22, did you say?
well, 22 onwards, I'd say 22 to 29 broadly. Not all of it is equally relevant, but
But surely we don't need 21 to 24 at all, do we?
well, the point in 21 to 24 is simply to give the concept of jurisdiction the broad definition. So it includes both territorial jurisdiction as well as issues of service.
Okay.
Just to make that good. There's also an issue raised here as to which, because Rule 11 is bringing together two different orders, as it were. So there is some clarification of this here. I don't think anything turns on it.
Yeah. Yes.
So the perhaps main points to make from this important decision is that once an acknowledgement of service is filed, then Rule 11 is engaged. And so if you don't challenge the jurisdiction under Rule 11, then you're stuck with the jurisdiction. And this is the case even if the claim form has expired.
And even if what? Sorry.
Even if the claim form has expired at the time of service. And the second point is, this is of tangential importance. In this case, a different application was made, an application.
You say in this case, you mean in Hodnot?
Yes, I
Yeah.
beg your pardon. In application to, well, a response, in opposition to an application to extend time for service that was made. And that was considered not to matter.
Yeah.
So effectively, 11.1.5 is possibly in contrast to some of the rules we've looked at today, clearly worded. You have two conditions. If you satisfy those, then the defendant is to be treated as having accepted that the court has jurisdiction to try the claim.
Yes, my lord. The other important decision is Patiala, which was decided by this court.
Italia.
I beg your pardon,
Italia,
Italia,
yeah.
which was decided by this court just short of 2 years ago. Well, about 2 years ago. Now, this case does not require quite as much attention. It relies heavily on the first case, on Hodinot. And the facts of this case were that the defendant didn't tick the appropriate box in the acknowledgement of service, so that the claim form was served out of time. Perhaps I should let your lordships read the head note.
Yeah.
So in this case, the appropriate box was not ticked on the acknowledgement of service, but instead there was a covering letter which explained that the defendant challenges service on the basis that the claim form was served late. And then the defendant made an application to strike out the case, and the court applied CPR 3.10 to correct those mistakes. So it treated the claim, the appropriate boxes have been ticked on the acknowledgement of service, and it treated the strikeout application, which was all but a Rule 11 application, as an application to challenge the jurisdiction of the court. And Rule 310 was held to be capable of correcting those procedural errors.
So the claims were reinstated.
Well, no, the claims were not reinstated because the defendant was held to be able to challenge the jurisdiction
Yeah.
of the court.
Yeah. Are there any particular parts of the judgment you want to show us?
I would, for present purposes, it repeats very much the same rule as Hodinot, which it relies on. I don't propose to.
The key reasoning of Lord Justice Bean is extremely clear and succinct. It's at 33 to 38. Makes a distinction between the present situation and 7.6.3. Actually. Distinguishes Hodinot and Venus. Yeah. So what do you get out of that?
I beg your pardon?
So what's your submission based on Pitalia?
I'm including Pitalia for completeness because it's important that the court has all the authorities. There isn't any different. There isn't anything different to be drawn from that as compared to the first case. So then at whenever your lordships are ready.
Right, yes, we're ready. They're waiting for us. We're ready.
Yes, my lord. I beg your pardon. So then at paragraph 7 of my note, I ask, well, what is then the question? What is then the position where the acknowledgement of service has not been filed?
Yeah.
That question is I say, an important one because if you have a code for dealing with jurisdictional issues, which includes disputes about service, then can it be right that you can avoid going through the relevant steps simply by failing to file an acknowledgement of service? Now,
What do you mean by the relevant steps?
Well, the steps of first filing an acknowledgement of service indicating that you're challenging jurisdiction, and then
Is there an obligation to do that? Where do you get the obligation to do that? We didn't. I thought when we looked at 11.1. We didn't see one.
Is it 11.2, which is if you wish to dispute jurisdiction, then you must file an acknowledgement of service in part
Thank
10.
you. Well, my lord is right and I'm wrong.
Yes, but that then raises.
Which is to make. Well, how? Which is to make. Yes, I see.
That was the sort of purist approach taken in Hodinot.
Yeah.
Another relevant provision is 10.1, which says that the defendant must file an acknowledgement of service if they wish to dispute the court's jurisdiction.
Yes, I see. No, but I'm wrong. Don't spend any more time on it.
Thank you, my lord. So the next case is at tab 4, page 51 of the Supplementary Authorities Bundle. This is a case by Lord Justice Nugee, and it is called Handheld Products against Zebra Technologies. Facts of the case are not tremendously interesting. Safe to say that the case is concerned with a situation where several companies were served, and one of those companies claimed that it hadn't been correctly served because the claim form had been delivered to the wrong address, and it applied for service. It applied for an order that the claimant serve properly under CPR 7.7.
Sorry, which page is this?
It starts at 51 in the bundle.
And the paragraphs I intend to rely on start at paragraph 70. Which is at page 73.
Sorry, which paragraph?
So I propose to take your lordships through it, but it begins at paragraph 70.
70.
Yes, 70. It's not all of this that's relevant.
No, because this is
The most relevant bit really starts at 77, doesn't it?
Yes, my lord.
So how much of it are you wanting us to read? Speaking for myself, I've read up to 80.
Yes, that was actually precisely the paragraph that I would invite the court to read to.
And so what do we get from that?
Yes, my lord. So this is all obiter, and I should say that Lord Justice Nugee here is sitting in the High Court.
Yeah.
And the argument being made is precisely the argument that I'm making, which is that all jurisdictional questions should be considered under Rule 11. This is at paragraph 70, where that proposition is stated by reference to one of the parties' counsel. And Lord Justice Nugee says, well, that is possibly the case at 79, but what happens if, for example, the letter is delivered to the wrong address? Might there be other CPR provisions where question of service should be considered? And then he says that certainly for present purposes, in the context of 7.73, it is necessary to consider whether service was effectuated the first time the claim form was delivered, and whether therefore it is necessary for the claimant to, so to speak, to deliver it again, but this time effectuating service correctly.
What do you say about the last sentence of paragraph 79?
Yes, so I say, of course, that well, Lord Justice Nugent says it does not necessarily follow, and hence I say that I put this as an invitation to the court to actually decide the point. I say that if paragraph 11, if Rule 11 is not interpreted as, actually so I make two propositions. The first proposition is that Rule 11 should always be used to challenge service. And service cannot be challenged in another context.
Always be used to challenge service.
I'm sorry. I'm very sorry, my lord.
It's all right. It's getting late. Do you mean jurisdiction?
Jurisdiction in the broad sense to include service,
Yep.
issues of service.
So your first proposition, Rule 11, should always be used to challenge jurisdiction.
Yes, my lord.
Yeah. And your second?
My second proposition is that that is tempered by the notion that there will be instances where questions that are relevant to service will be incidental. So the example given here is 7.73, where the question of service came up in an application and had to be decided, but that was not in application to challenge jurisdiction. Because in handheld devices, there was no jurisdictional challenge. It was an application to serve a claim form, to compel the claimant to serve the claim form. So that is not a jurisdictional challenge.
And if one's looking at the scheme of the CPR, it all starts by requiring an acknowledgement of serving. So it's albeit preserving issues of jurisdiction. So you shouldn't actually start to engage without having acknowledged service.
Yes, no, that's precisely the submission that I wish to make. I've already referred the court to Rule 10.1, which specifically states that. Uses the word must. The defendant must file acknowledgement of service if it wishes to challenge jurisdiction. So at paragraph 10 of my note, I make 4 arguments as to why it must be so. First argument is that if you permit a defendant to challenge jurisdiction in a different procedural context without filing an acknowledgement of service, well, in theory at least, Google in this case, suppose that the claimant wins this appeal, Google could then file an acknowledgement of service and then challenge jurisdiction again, for example, on a different basis, or on the basis that it has different arguments which were not considered the first time round. That, I say, is desirable, highly undesirable. It shouldn't be the case. My second point ties in with the first one, and it is that a defendant not filing an acknowledgement of service is placed in an advantageous position. It is an anomalous and unjust result because the purpose of Rule 11 and of the requirement to follow that procedure is, of course, that at a very early stage of the proceedings, you have certainty about whether or not the court has jurisdiction. Whereas if, like in the present case, the defendant doesn't file an acknowledgement of service, you have uncertainty.
What practical difference would it have made?
Well, to begin with, and this is my fourth point, to begin with, well, two practical differences. The first one, of course, is that costs would have followed the event.
Well, that I follow. I follow the cost point.
Yes, my lord.
Well, it certainly would have made the cost point clearer and possibly easier to argue.
Yes.
But what else?
Well, one of the difficulties in this case was that until the hearing before Judge Grout, or very shortly before then, it wasn't actually clear what precisely the arguments were. Whereas if the defendant
In relation to what?
in relation to territorial jurisdiction.
Right, so the Equality Act point.
Yes, and in fact, I wrote a letter to Google's solicitor asking him to explain the point, and he refused. He said that there was sufficient notice in the defendant's skeleton argument for the first hearing, which really didn't explain it in much detail. Whereas if the defendant had been compelled to make a formal application, then that application would have had to contain the requisite reasoning, authority, and so on. The final point is, of course, one I've already made, which is that the relief from sanctions application is not the correct place to determine that issue. Of those 4 points, I say that the first one is the most important.
Yes.
Because that is the point that suggests that the position we're in is an anomaly. Paragraph 11, and I think I'm coming close to the end. Paragraph 11 considers what is the position in other procedural contexts. So, for example, this is in response to Lord Justice Nugie's, the concerns that Lord Justice Nugie raised.
The 773 point.
Yes, because it's not just 7.7, there could be other procedural contexts
Yes.
where questions of service arise. And I say that if, for example, if there's any doubt about service, it is for the defendant to challenge jurisdiction. Now, Lord Justice Nugie says, well, what if service has been effectuated correctly, but the delivery, the mailman or the delivery person, the process server, delivered it to the wrong address? If you're serving by post, then if you've put it in the post box, then that's valid service. It doesn't matter if it's been delivered or not. So what about a situation like that? Wouldn't you need to consider service if the defendant hadn't received it, especially if it is a question that comes up in a connection with Parts 12 or 13, in a default judgment application or an application to set aside default judgment? And I say that in that context, you're looking at two different situations. The first situation is where the defendant didn't receive the claim form and so didn't know about it. Whether or not service was effected correctly, what you're challenging at that stage is delivery. You're saying that I didn't receive the claim form and therefore I should be given another chance to contest the claim. That is different from challenging the court's jurisdiction. The other situation is where you have received the claim form but didn't challenge jurisdiction. If you then, if an application for default judgment is then made, then you cannot challenge jurisdiction in that context because that ship has sailed, so to speak. And that distinction deals with the sorts of practical situations that might arise that Lord Justice Nugent mentions in his judgment.
Right, now let's just take stock. You have developed your broad point on Rule 11 in the context of the cross application. What more do you need to say about it in the context of the appeal?
Well, in the context,
I'm inviting you to make the submission now. I'm just trying to see effectively whether we should rise now, but I just want to see and how, what the shape of tomorrow will be.
well, I would invite the court to rise now because this is what I meant before when I said that there are nuances that need to be considered, because if I'm right, then the implications are that, well, potentially the implications are that neither Judge Grout nor this court has jurisdiction to hear effectively this appeal.
Okay, but sorry, so that you need to develop that point, and so that's one thing that's on the agenda. Then that's it. Then we will have to hear from, is it going to be Mr. Roberts?
Yes, my lord, yes.
Then we'll hear from Mr. Roberts on both that point, the Rule 11 point, as it affects the appeal and as it affects your cross appeal, and then also on the distinct point about the costs, but whether it's unprincipled or the adequacy of reasons and all that.
Yes, my lord.
Well, that's the agenda for tomorrow. I don't think we need to grab the last 10 minutes in order to have plenty of time. There will be plenty of time tomorrow on any view. We're not going to go the whole morning. No. Very well. Unless my lords have been here, we'll rise now and sit again at 10:30. Thank you very much.
All rise.